Okay, I will say a few words, first of all, on the intermediate exam. It was asked by some of you, but I was going anyway to say something about it. So we will have the program for the intermediate test will include all what has been done until now, plus the today's subject, which will be the domestic courts and international law, and this is chapter 16 in your textbook. Anyway, the pages then are written on the slides, and then we will have the subjects of international law, states, and jurisdiction, powers, and immunities, which are chapters 4 and 5, but it will not be the whole of chapters 4 and 5, but a part of chapters 4 and 5. In essence, I will write it on Arial later on. And as I already told you, the intermediate test will consist of 2 written questions. One will be a question just based on a subject contained in the program, and the other will be a case. So the exercise you did on the reservations was useful because it is something like that. The difference is that you don't choose. In the case of the intermediate exam, you will not have to choose a case, but I will give you the case and you will have to give your solution, your interpretation. Now we'll say something on your exercises. I think you did very good exercises. I cannot talk about each one of them. Anyway, I think they are useful also because some they show that there was a need to clarify some issues, some further issues in relation to reservations on one side, and on the other side that there are still some misunderstandings on reservations. So a certain number of you chose the Convention on the Rights of Women, which is very good, of course, and very important. I guess you chose it because, not only because it is important, but also because you read, there was a suggestion on that in your textbook. On the conventions relating to the rights of women. Anyway, it is clear that the conventions, as raised by many of you, the conventions, the reservations issued by various Islamic countries in relation to that convention pose problems in terms of compatibility with the object and purpose of the convention, because on one side, these countries say, yes, we ratify, so we accept the principle of the non-discrimination of women, but on the other side, if they reserve the respect of national laws, of Sharia-based national laws, which are contrary to that, this is obviously contrary to the object and purpose of these conventions. As for territorial limitations, these are specific kinds of reservations. Well, sometimes it is the treaty which will provide for the possibility of, but I mean, it is something different than a reservation on the content. It is the fact that some of you cited declarations according to which one state said this convention will not apply to my dependent territories. So what we were called colonies once, I mean, small, there are still states having some small dependent territories. This may be a problem in a convention relating to the protection of human rights, for example. But it is usually in many conventions, for example, in the treaty on in the EU treaties. EU treaties are not applied to Greenland according to deliberation that was taken by Denmark on the basis of also if I remember correctly, of a referendum that was held in Greenland. The Greenland was excluded from the participation in the EU treaties, and also other EU countries exclude some of their dependent territories from participation in the EU treaties. This is perfectly compatible with the object and purpose of the EU treaties, because the EU treaties are based on a union, in fact, of European countries, and so the fact that non-European territories may be excluded is not contrary to the object and purpose of the treaty. A certain number of you quoted reservations-based declarations granted by the treaty itself. So, for example, when you have the Convention Against Torture, and you mention Israel, Francesca, here, which declares that it will not recognize the competence of the committee, the inquiry committee, which is provided in Article 20 of the Convention. But there is Article 28 in the Convention Against Torture, which provides for this possibility. So this is an option which is granted by the treaty. So it is not a reservation. The reservation is something that the participating state unilaterally decides to exclude, while here it is the treaty itself which grants the possibility to an option to its states parties adhere or not adhere to certain provisions of the treaty. So you have some treaties containing opt-in provisions and treaties containing opt-out provisions. So a state may declare which provisions it will accept, opt-in, or a state may declare that it will not accept a certain provision, opt-out. These are not reservations. It is the treaty itself which grants this option. it is correct to say that obviously a reservation to the, for example, to the Convention on the Rights of the Child, Francesco, by a country such as Indonesia, which declares that the ratification does not imply the acceptance of obligations going beyond the constitutional limits of the country. This is not acceptable. And there are similar reservations by the United States to certain treaties. This is not acceptable because a country is saying, I just adhere within the limits of what my constitution, when it may be that its constitution is perfectly compatible with the convention, but it may also be that the constitution will and the problem here is that it is a general reservation. So you don't know in the beginning what this will entail, because every time you will have to see if the obligation undertaken by the state is compatible or not with its constitution. So it's something that you can verify only case by case, while a reservation should clearly state what you are excluding or what you are interpreting and how. Anyway, this is more of a, I would say, more of an interpretive, conditional interpretive declaration, because yes, I mean, you can say everything which will be incompatible with the Constitution will be excluded. So in this sense, is a type 1 reservation, but of course, a type 1 reservation is not only when there is a clear-cut reservation which says I exclude Article 27, but also when the declaration entails excluding the application even of a single part of an article or of single provisions. These are always type 1 reservations. If you have any question, of course, or comment, you may intervene. And then some of you, as I was saying, it seemed to me there was some misunderstanding on the concept of interpretive declaration or conditional interpretive declaration. So first of all, we have declarations. We need to interpret whether they are reservations or not. So if you have a declaration excluding application of part of the treaty, this is a reservation type 1. If you have a declaration interpreting in some way a provision of the treaty, you will have to verify whether the state merely proposes an interpretation. In that case, it is a simple interpretive declaration. It is not a reservation. Or if the state wants to impose its interpretation, and this is a conditional interpretive declaration, and this is a reservation. Now, it is not true that the state shall necessarily say in explicit words that it intends only to accept a certain the interpretation it is proposing. It is a question of interpretation. And normally, if a state proposes an interpretation, normally it is because it only accepts that interpretation. So it is a question of interpretation of the declaration. The question of Anna, it is a general reservation considered contrary to the object and purpose of the treaty. Well, there is case law on that. The European Court of Human Rights, for example, considered general reservations as incompatible with the object and purpose of the treaty because of what I was saying. Because a general reservation is something which does not clearly state what you are accepting, what you're not accepting. And so it could be considered as incompatible with the object and purpose of the treaty. Well, some of you say this reservation is incompatible, this reservation is compatible. Okay, you should say 2 words to explain why you think it is compatible or incompatible. It is obvious that all the reservation concerning, we have mentioned that during our class, all the reservations concerning the exclusion of the jurisdiction of the International Court of Justice, that they are normally compatible with the object and purpose of the treaty, because the provision on jurisdiction is certainly important, but it is not essential to reach the object and purpose of the treaty. Then we have some interesting declarations that are quoted by some of you. For example, Vienna Convention, Cuba's reservation to the Vienna Convention on diplomatic relations, and this was Tommaso. Cuba makes a reservation with respect of the articles of the convention concerning ratifications. It says that it does not, it reserves in relation to the provisions of Article 48 and 50, which say that the convention shall be open for signature to all states, by all states members of the United Nations, or parties to the statute of the International Court of Justice, and by any other state invited by the General Assembly. Cuba reserves, because it says the revolutionary government of Cuba favors facilitating the admission of all countries without any distinction. So Cuba does not like these distinctions which were introduced in relation to that only states belonging to the United Nations or invited by the General Assembly may participate. But this is not a reservation, this is a protest by Cuba. Why do I say it is a protest and not a reservation? Although Cuba uses the terms reservation. Yes, please. So? Yes. I mean, Cuba is not able to influence the fact of who will be admitted. It is written in the treaty, only those states will be admitted, so Cuba has nothing to do about it. It is just a protest that says, I would prefer that this would be open to all states, but it has no effect. The provision on the Savoy, that is interesting, yes, Alessandro, on the International Covenant on Civil and Political Rights, the former provision of the Italian Constitution, which excluded the Savoy from entering the Italian territory. Yes, it may be debated whether this was in contrast with the object and purpose of the treaty. Of course, on one side we can say it was, on the other side we can say it is very limited and due to historical reasons, but of course we can discuss about an incompatibility. Then the declaration, this is Anna's, the declaration of Columbia with respect to the Convention on the Rights of the Child, where Columbia declares that it recognizes the age of 18 years as a limit for children for participation in hostilities and not 15 years. This is not a reservation because the convention provides for a limit of 15 years, which, as you, Anna, say, it does not prevent a state from granting a better protection. So this is not a reservation. The state can always, in a human rights treaty, a state can always grant a better protection than what is provided in the treaty. So it is not a kind of reservation. Okay, then sometimes there is some misunderstanding with the content of some articles of a treaty, but I mean, this is a different problem than the problem relating to reservations. Anyway, every time you have a statement in a provision of the treaty which allows a state to declare that it does not accept something, this is not a reservation because it is a declaration, an option which is provided by the treaty itself. Okay, I think I said I touched the main points that I wanted to touch. As I said before, if you have a provision of the treaty which allows states to declare that they will not accept another provision of the treaty, this is an option which is granted by the treaty itself. So it is not a reservation. If the state declares, it is just using an option which is granted by the treaty itself. So there is a difference in a provision in the treaty which says only articles 5, 7, 9, 11, 14, 15 may be subject to reservations, because here the treaty does not indicate the content. So in those cases, if a state reserves, it is a reservation. Another thing is saying states can declare, while ratifying the treaty, they can declare they will not accept Article 15. In that case, it is an option which the treaty specifically provides. Okay. Anyway, as some of you did very good, I mean, all of you did a good job, but some of you did a very good job, and so some of these exercises will get a plus or 2 pluses for the final grade, the final mark for the exam. But anyway, I will decide it and tell to the interested people who will get the plus or plus plus. just an indication for the final mark. Any question on the on your exercises or on the intermediate exam? Yes, please. No, I will divide you because anyway it is better to not to have a completely full room. So you will be sitting one, leaving each time one place in the middle. So I will divide you in between the 2 days. There is also a question by Elisa. Could you please repeat again the 2 kinds of reservation? Okay. The first kind of reservation is a declaration which excludes the application to that state of a certain provision of the treaty. While the second kind of reservation is a declaration on the basis of which the state gives an interpretation of a certain provision of the treaty, intending to accept only that interpretation, which means that if the other states accept a different interpretation, this means to modify the effect of that provision of the treaty with respect to the state in question. So this is an conditional interpretive declaration, and it is the second type of reservation. Yes, please. No. Sorry? I didn't understand, sorry. If you can say it loud. No. Just excluding, but not necessarily general reservation. There is a question on, can the intermediate exam be online? No. The intermediate exam is an option I gave you. It is not binding, and it is only in class in the 2 days that I said it is 4 and 5 of November. During the class hours in this classroom number 5. I'm sorry if some of you cannot attend, but this is an option, of course, for the final exam, if there will be impossibilities to attend, the possibility to take them online will be granted. Okay. Any other question? Cecilia, so would the declaration saying a state will accept an article only as far as it is compatible with its legal system be a reservation? Yes, absolutely. And this is a kind of general reservation. As I mentioned, because it doesn't state specifically what it is excluding. it is type, it is we may say that it is probably, we could say it is type 2, but I mean, the state is not proposing a clear interpretation, but it is saying that the article shall be applied in a way which is compatible with the legal system of the state. So it is the declaration. We can say that on one side it is excluding applications of that article which are incompatible with the legal system of the state, but this of course requires an interpretation every time to understand what is compatible and what is not compatible. So we could say it is type 1, but however it requires of course an activity of interpretation to apply it. Okay, any other question? Okay, so let us go back to what's it? Chat. Okay, this is nothing to do. And okay. Let us go back to our lecture concerning the circumstance. If somebody has its microphone on, his or her microphone on, please. Okay, now there seem to be trouble. So to the circumstances determining the termination of a treaty, we have considered the general provisions on denunciation or withdrawal. We have considered the material breach as a cause of termination of a treaty. We have considered the supervening impossibility, rebus and rebus sixtantibus. Now, let us consider this case, Gavčíkovo Nagyamaros. I think it's pronounced more or less this way, or Gavčíkovo Nagyamaros, I don't know. Anyway, this was a case. Okay, I have an intervention, maybe saying what is the correct pronunciation. Oh, you cannot see the slides. You are right. Sorry, I have to share my screen. Can you see them now? Okay, I guess you can see them. Okay. So in this case was a case between Hungary and Czechoslovakia. But when it was decided, Slovakia was the successor state in this case to Czechoslovakia, because the question concerned the use of a river, which is the Danube, in fact, which is situated at the frontier between Hungary and Czechoslovakia at the time and now Slovakia. And this treaty, 1977 treaty, provided for the construction of a system of locks on the Danube. And now it happened that Hungary at a certain moment in the beginning of the 1990s felt that going on with the construction of this lock system would entail serious environmental problems for environmental consequences for Hungary, for the Hungarian territory. And therefore, Hungary invoked the termination of the treaty on various grounds. In particular, Hungary, well, it also invoked issues of state responsibility, but we will consider that later on. But it invoked, in particular, the rebus sic stantibus principle. Now, the court takes into account the Vienna Convention, which was not applicable as a treaty to the case, but it analyzes the Vienna Convention and it considers the Vienna Convention as, at least some of the rules of the Vienna Convention, as a codification of existing customary international law. And this applies to the provisions, according to the court, in particular to the provisions concerning the termination and suspension of operation of treaties set forth in Articles 60 to 62 of the Convention. Hungary, in particular, contended that the essential object of the treaty, which was an economic joint investment consistent with environmental protection, had permanently disappeared. So a first cause invoked was the impossibility of performance, Article 61. Therefore, the treaty had become impossible to perform. Now, the court clarifies that in this case, even if it is not necessary for the court to determine whether the term object, let us go back to Article 61, the party may invoke the impossibility of performing a treaty if the impossibility results from the permanent disappearance or destruction of an object indispensable for the execution of the treaty. We mentioned that examples of real objects, of concrete objects. So the court is saying, I do not have to decide whether the term object can also be understood to embrace a legal regime, because even if that were the case, in this instance, that regime had not definitively ceased to exist. Why? Because the regime provided for the adjustments of this economic joint investment in order to take into account environmental protection issues. Adjustments had to be agreed to by the two parties, but anyway, the regime cannot be considered to have disappeared. Then a second ground invoked by Hungary was rebus sic stantibus, because Hungary invoked the radical change of the political situation. Of course, there had been the fall of the Berlin Wall and the fall of the communist regime in Hungary, and also in Czechoslovakia, which had taken place at the end of the 1980s and beginning of the 90s. And Hungary was invoking this and linking this to the fact that when the treaty had been concluded, there was no environmental conscience, as would only arise later on in the and that would be much more present in the new Hungarian regime. But the court underlines that the prevalent political conditions were not so closely linked to the object and purpose of the treaty that they constituted an essential basis of the consent of the parties. We are not talking of a political treaty between the two countries, strictly connected to the fact of having a communist regime at the time. We are talking about the treaty concerning the exploitation, the common exploitation of the waters of the Danube River. And therefore a treaty with an economic exploitation object, which could be compatible with a communist regime as well as with a democratic, liberal democratic regime. So this is not, the political conditions were not so closely linked that they constituted an essential basis of the consent of the parties, and in changing would radically alter the extent of the obligations still to be performed. The same holds good for the economic system in force. The fact that it was a planned economy and it became a capitalist liberal capitalist economy. Even though the estimated profitability of the project might have appeared less in 1992 than in 1977, it does not appear from the evidence that it was bound to diminish to such an extent that the treaty obligations of the parties would have been radically transformed as a result. And as for developments in the state of environmental knowledge, environmental conscience, and environmental law, the court does not consider that these developments were completely unforeseen. What is more, the formulation of some articles of that treaty between the two countries made it possible for the parties to take account of such developments and apply them when implementing those treaty provisions. These provisions provided for, as I mentioned before, adjustments which would take into account environmental considerations. Okay, so this is going back to Article 62. If you remember that a party may invoke the impossibility, a fundamental change of circumstances which was not foreseen by the parties may be invoked only if the existence of those circumstances constituted an essential basis of the consent of the parties to be bound by the treaty, and the effect of the change is radically to transform the extent of obligations still to be performed. So the court is, the interpretation given by the court clarifies that, in fact, the the rule rebus sic stantibus, the exception, the cause rebus sic stantibus, tend to be denied in each specific case because it is, as I mentioned, the rule that puts into peril the survival of treaties. It puts into question the principle pacta sunt servanda, and therefore courts are very much strict in allowing the invocation of this provision. Then finally, Hungary claimed that it was entitled to terminate the 1977 treaty on the ground that Czechoslovakia had committed a material breach of the treaty. Now, the point is that after Hungary declared to withdraw from the treaty, Czechoslovakia had diverted the waters of the Danube in a certain area. So this was a reply, a countermeasure adopted by Czechoslovakia to react to the Hungarian action. And this measure was, in fact, considered as wrongful by the court, the measure adopted by Czechoslovakia. However, the court is saying Hungary cannot invoke the material breach of Czechoslovakia because Hungary, by its own conduct, had prejudiced its right to terminate the treaty, because before Czechoslovakia adopted this wrongful conduct, Hungary had committed a wrongful act. Please, I remember that one has to wear the mask in class during the whole lecture. Thank you. Hungary had prejudiced its right to terminate the treaty because Hungary had committed this its own violation by withdrawing illegally from the treaty in violation of customary international law before Czechoslovakia committed its material breach of the treaty. So even if the Czechoslovakian conduct can be considered a violation of a provision essential to the accomplishment of the object or purpose of the treaty, Hungary had already committed a violation of the object and purpose of the treaty by illegally withdrawing from the treaty, declaring to withdraw from the treaty before. And so Hungary cannot invoke the material breach of Czechoslovakia as a cause of termination of its participation in the treaty, and therefore of denunciation of the treaty and termination of the treaty itself. Therefore, all the causes invoked by Hungary are not recognized by the International Court of Justice. Is this clear? Is something not clear? Yes, please. Yes. Because Hungary was invoking that an economic joint that the treaty was the essential object of the treaty was an economic joint investment consistent with environmental protection. As the application of the treaty between the two countries was now prejudicing, in Hungarian view, Hungarian environment, Hungary invoked that the treaty had become impossible to perform because the essential object of the treaty had disappeared. So the court says, I do not need to decide whether the essential object of a treaty can also be an economic joint investment consistent with environmental protection, so a certain regime. Because anyway, this regime has never disappeared. This regime is still there because the treaty provides for an economic joint investment consistent with environmental protection. The treaty includes provisions for adjusting the execution, the implementation of the treaty on the basis of environmental considerations. Is that clearer now? Well, it is an interpretation attempted by Hungary. Hungary claims that as the treaty, as the application of the treaty had become incompatible with the protection of the environment, so this essential object of the treaty, an economic joint investment consistent with environmental protection, had ceased to exist. This was the claim by Hungary. No, legal regime means the legal regime included in the treaty, which provided for how to realize an economic joint investment consistent with environmental protection. Yes, please. Yes, yes. Yes. And the third part with the material breach. So Hungary was invoking impossibility of performance, rebus sic stantibus, and material breach. But none of these causes was considered by the court to be acceptable. Okay, any question at home? Now let us come to the second case, the Racke case. This is a case decided by the Court of Justice of the European Community. Now, the Racke case concerned the fact that it was a preliminary ruling, so this is specific jurisdiction of the Court of Justice of the European Community. Anyway, the Court of Justice was deciding a claim that, according to which, because the European Community had decided to suspend a treaty, an agreement, a cooperation agreement with the Federal Republic of Yugoslavia due to the war situation. In particular, the treaty, the cooperation agreement, promoted the development of Yugoslavian economy. So, for example, it granted some preferences in the trade between the EC and Yugoslavia to promote the development of Yugoslavian economy. Now, due to the war, the but in fact also as a sanction against the Federal Republic of Yugoslavia. The EC decided to suspend the agreement, or to terminate the agreement. Now I don't remember if it was termination or suspension. Anyway, the Court of Justice recalls Article 62, paragraph 1 of the Vienna Convention, laying down two conditions. First, essential basis, and second, radical transformation of the extent of the obligation still to be performed under the treaty. And concerning the first condition, it recalls that what was the purpose of the treaty, as you can see from the slides, and the fact that its provision should contribute to the economic and social development of Yugoslavia and strengthen relations between the parties. Now, according to the court, in view of such a wide-ranging objective, the maintenance of a situation of peace in Yugoslavia, indispensable for neighborly relations, and the existence of institutions capable of ensuring implementation of the cooperation envisaged by the agreement throughout the territory of Yugoslavia constituted an essential condition for initiating and pursuing that cooperation. And regarding the second condition, there is no point in continuing to grant preferences with a view to stimulating trade in circumstances where Yugoslavia was breaking up. So the Court of Justice of the European Community accepted in this case the claims relating to, of the European Community relating to the extinction or suspension of the agreement with Yugoslavia. There is a question at home. No, there is no question at home. Okay, so this was probably a large interpretation by the Court of Justice of the European Communities. This is a case in which an international court admits the possibility of applying the rebus sic stantibus principle, probably in a too lenient way, because we might question whether, of course, the amount of trade was reduced between the two parties, but there was probably no real justification for excluding the application of preferences to the amount of trade that was continuing to go on between the two parties. And so what was, in my view, probably the court should have interpreted the suspension decided by the European Community as a sanction against Yugoslavia, so something different from a measure fitting into the law of treaties, but rather fitting into the law of international responsibility, which is something different. So this interpretation given by the court in this Rake case may be questionable. Anyway, this is a successful invocation of the rebus sextantibus. Any question? Now this helps me in mentioning another point. I also mentioned it with some of you the other day. What happens with war? The effects of war on treaties. Because once upon a time, in international law, it was considered that war automatically extinguished treaties between the two parties involved in the war. In fact, it was even considered that war suspended the operation of what was considered as the international law of peace and would put in force the international law of war, which is in fact the international humanitarian law, what we today is called international law of armed conflict or international humanitarian law. Today, this concept is no more recognized. It is considered that, so one doesn't talk anymore about the international law of peace. One talks about international law, and that's it. And international law, it's applicable in time of peace, and it is also applicable in time of war. So there is no suspension, no general suspension of international law in time of war. It is true that the international law of armed conflict explicitly applies only in a situation of war, but this does not mean, does not entail the extinction or the suspension of the rest of international law in a situation of armed conflict. What we can say, however, is that certainly a war between two countries will extinguish or at least suspend agreements which are totally incompatible with the situation of war. For example, a treaty of alliance, if a NATO state should commit an aggression against another NATO state, it is obvious that the NATO agreement, the NATO treaty, would be suspended, if not extinguished, between the two states in question, because a treaty of alliance, even a treaty of self-defense between two parties is totally incompatible with an armed conflict between these two parties. But nowadays, states even maintaining diplomatic relations sometimes with other states with which they are involved in an armed conflict. So normally today, you really need to have a total incompatibility to consider that a certain treaty is automatically suspended or extinguished as a consequence of the existence of a state of armed conflict between two countries. Any question? Is that clear? Okay. So we leave the law of treaties for the moment, and we go to the question of the relationship between international law and domestic law, and national law or domestic law or municipal law. It is all ways of calling the same concept. internal law. So this relationship is extremely relevant because as we already mentioned in the beginning of these classes, international law does not only concern the field of international relations. International law nowadays regulates many instances, many situations, many subjects that relate to the internal life of states. And this means, as a consequence, that states, being states bound to respect international law, they have to make so that their domestic law is in compliance with international law, because they have to apply international law within the state. In order to apply international law within the state, you need to have compatibility between the national legal system and the international legal system. Now, the only thing which is required by international law is that states respect it. The interest of international law is to be respected by states. And states cannot invoke their domestic law to justify the fact that they do not respect international law. We have already mentioned this several times. So how a state complies with international law will be decided by the state itself. What matters for international law is that the state respects international law. Now, it is true that you have two different approaches of states to the relationship, and also of experts, to the relationship between the international legal system and the national legal system. On one side, you have the dualist interpretation, which is, I would say, the prevailing one, probably, according to which international law and national law are two distinct legal systems, two separate legal systems, not interfering with each other. And this is, for example, the approach followed by Italy and by many other countries. While according to monism, international law and national law are part of one single legal system. This was, for example, the view of a famous expert, a famous philosopher, jurisprudent, Hans Kelsen. He was Austrian, but then moved to the United States and became naturalized American. So he wrote in the first part of his life in German and then subsequently in English. According to Kelsen, there was only one legal system. And this legal system could be based, in fact, on two different premises, either that national law is superior to international law, or that international law is superior to national law. Kelsen himself preferred the second option, so international law is superior to national law, which means that there is a hierarchy, and international law is at the top and domestic law is at the bottom. And therefore, according to monism, the foundation for national legal systems is in international law, which means that it is international law which provides for the basis, the foundations for the existence of states' legal system, of domestic legal system. Now, for example, monist legal system is the Netherlands, which is the legal system in which, of course, the author of your textbook was formed. However, in your textbook, you find an interesting discussion about these two theories, monism and dualism. Theoretically, we may say that theoretically, monism would not require any implementation of the international legal rules into the national legal systems, because as you have, according to monism, one single legal system, international rules are by definition part of the national legal system, and by definition they prevail over the national legal system, as there is this hierarchy that I was mentioning. While according to a dualist perspective, as international law and national law are two totally separate legal systems, in order to apply international law into national law, you necessarily need to adopt national laws which implement the international legal provisions into the domestic legal system. However, this is theory, because even the author of your textbook recognizes that, apart from the fact that probably no legal system is perfectly monist and no legal system is perfectly dualist, but there are some mixed forms of monism and dualism. But apart from this, monism and dualism do not provide the answer to all questions relating to the implementation, how international legal norms can be implemented into the national legal system. So you need to look into the constitutional rules of one or the other state to understand how the international rules are implemented into that specific domestic legal system. And this happens both for so-called monist states and so-called dualist states. In fact, all national legal systems provide for different means of incorporation or reception of international law within domestic law. In Italian, you would talk about adattamento. According to the Italian legal language, the domestic legal systems need to adapt itself to the international legal system. So, adattamento del diritto interno al diritto internazionale. But this is how it is expressed in Italian, while in English you talk about the implementation of international law into domestic law, or the incorporation or reception of international law within domestic law. So you cannot just look into the theories and derive from monism a certain way of implementing the international rules, and from dualist another way of implementing international rules. Each country, each state decides how to adapt its legal system to international law, how to incorporate international rules into the domestic law. In fact, we can say that because a dualist country theoretically could also decide that it is not interested in international law, but this is not the case. All states are interested in respecting international law, and therefore all states provides for means of incorporation of international law into domestic law. Are there questions up till this point? Because the point is that international law now, in many cases, rules not on how war has to be conducted between state A and state B, but for example, on how the state shall treat individuals. So relationship between the state and individuals, or even relationship between individuals. So this means that these are situations which are normally governed by internal law, by domestic law. Therefore, either domestic law is already compatible with international law, or otherwise you need to modify domestic law in order to render it compatible with international law. Now, let us touch the point of self-executing norms. This is a difficult concept which is specifically belonging more to the common law legal systems, but anyway, it is, I think it is a useful concept. But you have to take into account that this concept can have two different versions, two different interpretations. In a first way, in a first version, you can intend self-executing norms or even self-executing treaties in a formal sense, in a purely formal sense. In that sense, a treaty or a norm or an international norm is self-executing in the sense that it does not require a domestic act incorporating it into municipal law in order to render it applicable within the state. And in order to allow any subject, so even any citizen, any individual to invoke that rule before the courts, I mean before the national courts. Theoretically, a monist country should consider that treaties are self-executing. when they enter into force, they are self-executing, because they already belong to the national legal system. But I say theoretically. In fact, when you have a constitutional provision, as in certain countries, that provides that duly ratified treaties are parties of the domestic legal system, this is already an incorporation that you have in the text of the constitution of the state. We may say that in this case it is the constitution itself which incorporates treaties into the domestic law. So once again, it does not matter very much that the state is monist or dualist. An example. US constitutions, treaties made under the authority of the United States shall be the supreme law of the land. So they are law of the land. Supreme, we will see it after, but they are law of the land. They are domestic law. French constitution, treaties or agreements duly ratified or approved shall, upon publication, prevail over acts of parliament. This is a question of hierarchy, but it also means they are part of national law. If they prevail, is that because they are part of national law. So formal self-execution means you do not need a further domestic act to introduce the treaty or the norm into municipal law. It is already part of municipal law. And so it can be invoked as any piece of municipal law by individuals before the courts, by any subject before the courts of the state. But then you have a second meaning of self-executing, which is a substantial meaning. According to the substantial meaning of self-executing, a norm or a treaty is self-executing when it is sufficiently precise, when it contains all the elements which are needed to allow that treaty or to allow that norm to produce direct effects within the state. When the norm is not self-executing in a substantial way, this means that it does not contain all the elements that allow it to produce direct effects, and therefore it requires additional implementing legislation. For example, in the European Union, we will not deal specifically with the European Union legal system, but within the European Union, the most important act of legislation of the European Union is the regulation. According to the treaties, regulations of the European Union are directly applicable in the territories of all member states, which means they are as pieces of domestic legislation. They are directly applicable, but this is the formal concept of self-executing rule. This does not mean that a single regulation will be necessarily self-executing in the sense that it contains all the elements that allow it to produce legal effects. Sometimes you need further implementing acts to allow even internal provisions to produce legal effects. Even the rules of the constitution of a state are often considered not to be self-executing. They are, of course, part of the legal system, of the domestic legal system. They are even fundamental rules of the domestic legal system, but they are meant not to contain all the elements necessary to allow them to produce direct effects. And so they need further implementing legislation. For example, you have a constitutional provisions which says all individuals have a right to work. Well, this does not mean that it is sufficient for an individual to go to the state authorities and say, please give me a work because I have the right to work. This requires further legislation in order to grant the right to a job to all individuals. And we know how this is in fact impossible to reach, to effectively reach. So it is always important to have in mind this difference between formal applicability within the domestic legal system of a certain norm and substantial applicability, which means that the provision is perfect. It contains all the necessary elements, be able to be invoked by any subject, by any individual before the courts. Is this clear? Any question? Okay, we will then go on and see different means of incorporations of international law within the different states at the beginning of our next class. I made a mistake when I last day, when on Tuesday I inserted tomorrow's class in Teams, but I modified it because I had already, as you know, we had already communicated that there are no classes tomorrow, and so our next class will be on Tuesday. Okay? And if anybody of you wants to know about its specific exercise on reservation, you may ask, you may either come to see me or we can see each other on Teams and I can give you hints on your exercise, on your specific exercise. Okay, bye-bye to everybody.